Yes, let's get started.
Okay, thank you so much. Good evening, everyone. Thanks for joining us tonight at California Western School of Law, the presentation from Nadine Strossen and her talk entitled Hate, Should We Resist It with Free Speech, Not Censorship? I'm Danielle Jefferis. I'm a member of the faculty here at the law school where I teach civil procedure, civil rights law, and race in the law. Before we get started, I want to give some deserved recognition to the team who helped organize this event. I'm sure I will regrettably miss some of them, but I do want to recognize Liz Lechner, our events manager, Susan Finster and Jeff Chin in our Office of Student and Diversity Services, Professor William Aceves in our Diversity Committee, and Chris Van Nostrand, our Chief Marketing Officer, and his team. We're really excited to see such a great turnout here tonight and thrilled to welcome such an esteemed guest. Nadine Strossen is the John Marshall Harlan II Professor of Law, Emerita at New York Law School, and the former president and first woman to serve in the role of the American Civil Liberties Union. She's a leading expert on issues of constitutional law and civil liberties and has written 3 books, many book chapters, and many, many more law review articles. Her most recent talk, which is the centerpiece of this presentation tonight, is titled Hate, Why We Should Resist It with Free Speech, Not Censorship. It was published by the Oxford University Press in 2018 and has won numerous awards, including New York Law School's Otto L. Walter Distinguished Writing Award. It's also been translated into at least 2 languages and probably more at this point. Nadine re-released the book in 2020 with a new epilogue focusing on speech and social media. She's given hundreds of talks, interviews, and presentations around the world on her scholarship concerning free speech and social justice. And so we're very, very proud and excited to be among one of those presentations. But this talk tonight doesn't involve just Nadine. I'm also honored to welcome 2 members of our CWSL community who will join Nadine and myself in a conversation after some brief opening remarks. President and Dean of CWSL, Sean Scott, is here with us. Dean Scott's teaching and scholarship focus on legal education, contracts, and disability rights. She's been honored with numerous awards, including the Student Bar Association's prestigious Excellence in Teaching Award and the Black Law Student Association's Distinguished Faculty Award. And we are joined by Jayda Davis, a 3L student here at CWSL and the current president of the Black Law Students Association. Jayda is passionate about criminal law and has previously interviewed with the San Diego Public Defender's Office and is currently interning with the San Diego District Attorney's Office. Along with making the Dean's List, Jayda is the recipient of the Merit Scholarship and the Diversity Scholarship and has received an Academic Excellence Award in trial practice. In her very limited free time, she enjoys hiking and babysitting her 8-month-old nephew to Putasi. So again, welcome everyone. It's great to see such a large turnout. We'll kick off our conversation here in just a moment, but attendees and especially our students who are in the audience, please feel free to submit your questions via the chat feature. And as our discussion goes on tonight, I'll do my best to integrate them into our conversation. So Nadine, to get us started here, your book is titled Hate, Why We Should Resist It with Free Speech, Not Censorship. Will you just summarize your main points from the book for us and tell us why you wrote it?
Thank you so much, Danielle. It's really an honor to be participating in this event at your very impressive law school. And I'm so grateful to you and to Dean Scott and to Jayda for participating, because I am such a fervent believer in free speech. That means I want to engage in dialogue and honor other people's free speech, not just pontificate. But to answer your question and to get us started, Danielle, I became motivated and inspired to start thinking about and writing this book about half a dozen years ago now, when in response to tragic killings of unarmed Black men, we started to see a resurgence of campus activism in support of racial justice and then other causes, including gender justice, immigrants' rights, LGBTQ rights. That was really wonderful from my perspective, I had been a student activist back in the 60s and 70s, and campus activism really had died down in the interim. Studies and surveys were showing that students really didn't care very much about political or public issues, let alone become involved themselves. So I was certainly despondent about the horrific situations and killings that prompted the activism. But since we had these problems, thank goodness that students were galvanized to raise their voices and protest and organize and agitate. So all of that was positive. But there started to be a negative undercurrent as there were more and more episodes reported of incidents on campus where student activists were clearly saying that they were hostile to free speech, that they saw free speech rather than being their time-tested, essential ally, as I have absolutely known it to be throughout my career. They were starting to see it as somehow antithetical to their social justice and equal justice causes. So I thought clearly I and others who had tried to argue that freedom of speech is really the essential prerequisite for any other cause, certainly including racial justice and other human rights, that we clearly had not done a persuasive enough job. And so I took it upon myself as an advocate and as an educator to see if I could try to explain in more persuasive ways, not only to my prospective audience, but to myself, to the best of my human abilities. I really approached this in an open-minded fashion. I really thought, based on what I had observed, that no matter how well intended, censorship inevitably does more harm than good, specifically to the traditionally marginalized and oppressed individuals and groups, even when you're talking about censorship of hate speech. And so you're hoping to help those groups. But I was open-minded. It had been a while since I had looked into the issue, so I was glad to gather evidence from many countries around the world that do enforce hate speech laws. My overriding mission, as signaled by the name of the book, was to resist and is to resist hate. I mean, if you look at the cover design, which the designer really did a remarkable job, I didn't consult with him, but you see hate is the main subject there. But the only verb in the title is resist. Why we should resist it with free speech, not censorship. So my main goal is, how do we counter hatred, not only hateful speech, but the underlying attitudes that the speech reflects, and hateful actions, discriminatory and violent hateful actions. What is the most effective way for curbing them? And based on the extensive research I did, my prior presumption was reinforced. I saw human rights activists around the world, as well as in the United States itself, reaching the conclusion that no matter how well intended the censorship laws are, they are at best ineffective and at worst counterproductive in advancing the goals that we all share: diversity, equality, dignity, inclusion, societal harmony. So the bad news was that censorship did not seem to be an effective way to deal with these very serious problems. The good news, though, was very positive, and you can't be an activist without being an optimist, but I have a lot of reason for optimism. The good news is that there is so much evidence that there are so many other non-censorial steps that we can take and must take in order to counter hateful attitudes, expression, and actions. And just one example is what lawyers often refer to as counter speech, raising our voices. But I don't like that term for one reason. It sounds very defensive. You know, somebody said something hateful and then you counter it, you rebut it. I believe that every single one of us who is committed to racial justice and equality and human rights for all, which hopefully is just about every single one of us, that we have an affirmative, proactive responsibility to constantly be raising our voices, to speak in favor of the values that we hold dear, equality and dignity and diversity, as I said. And we have to use every opportunity to show our support for those goals and not wait until somebody or some group is disparaged. Now, certainly when that happens, we have a special responsibility to speak up. And notice that I'm talking about all of us. I do not at all see this as the responsibility of people who are themselves directly subjected to hateful speech. That should not be their burden. Hopefully they would feel empowered and inspired to speak up, but that's not their responsibility. It's the general responsibility of society. And I'm very happy that we've been seeing more and more such efforts by university leaders, by student leaders, by government officials. If you think about what happened after the Charlottesville catastrophe in 2017, there just about everybody condemned the white supremacists, with one notable exception, who happened to be the President of the United States. And do you remember how strongly he was condemned because of that failure? In retrospect, we understand it was one of the very few times that other leaders of the Republican Party, the Republicans in Congress, broke ranks and so strongly criticized Donald Trump. Military officials were speaking out. Donald Trump had two conferences or two groups, assemblies that he had put together, committees, I guess they were called, of top business leaders, CEOs of major corporations. And they were so upset about his failure to denounce the white supremacists that even though they supported his tax policies and his other financial policies, both of those committees disbanded. And we saw an outpouring of condemnation of hatred and support for diversity and equality at the grassroots level all over the country. Now, social scientists say that this is not a matter of just words. I mean, after all, hate speech itself is just words, and we know how powerful they can be. Social psychologists and other experts document that the power of counter speech is very potent. We should not underestimate it. So I really want to leave everybody with the message. It may not seem like a big deal to you, but it is a very big deal. Beyond that, let us not forget the work which we have made progress on, but much more progress needs to be made, of being sure that we have a full complement of anti-discrimination laws that make it illegal to discriminate on any basis. We have not completely done that in this country yet. It is still legal, unfortunately, to discriminate on the basis of gender identity and sexual orientation in many sectors of society. And even when we have those laws, we have to make sure that they are very strongly enforced. Same thing about so-called hate crimes laws, or I like to think of them as bias crime laws, because we're not punishing the emotion of hatred. We are punishing a discriminatory selection of a victim for what is independently a crime, independently of any motive or idea associated with it. So if somebody is assaulted because of a victim of assault is singled out because of discrimination against that person's religion or race or sexual orientation, that can be considered a more serious crime and subject to greater punishment or greater effort at restorative justice, whatever method we're using. So these are all very positive steps that we are taking more and more in our society, and I think where the future is. Let me just, I don't want to go on and on. I said that I'm speaking for many human rights activists from around the world. Let me end by just quoting one international human rights organization, the European Commission Against Racism and Intolerance. ECRI is its acronym. And ECRI has the responsibility of monitoring the enforcement of anti-hate speech laws that exist throughout Europe. And in its last report, and this is very typical, so I'm just giving you an example, it said that despite very strict anti-hate speech laws that are very strictly enforced, the problems of hateful, discriminatory violence and other discriminatory action in European countries has been mounting. Very disturbingly, a lot of this gets publicity in the United States. So some examples that have been well publicized are, brutal acts of discriminatory violence against racial and religious minorities, against refugees, against asylum seekers, against immigrants, against Roma. And the conclusion that ECRI, again, the European Commission Against Racism and Intolerance, I have this absolutely committed to memory. ECRI said that counter speech would be much more likely to be effective, much more likely to be effective than censorship. One of the differences that's been pointed out between European and other countries around the world that censor hate speech in a way that the United States does not, is that while those governments have more power to punish speech, critics from around the world have commented that in the United States, social pressure and peer pressure and government officials speaking out to condemn, not to suppress, that we have much more of that in the United States, and many experts believe that that is a more potent response, a more, not only a more consistent with free speech, but actually more effective in addressing the underlying problem. So I'll hold it at that and look forward to our conversation.
Go ahead, Dean Scott.
No, so I just kind of so thank you for that introduction. Lots and lots of stuff to unpack there. One of the so I have mixed feelings about how we respond to hate speech, and so one of the things that I find challenging in the argument of counter speech is that sometimes there isn't a counter. When somebody calls me a name, mm-hmm. It's I can certainly put my hands on my hips and say, I am not, mm-hmm. but that's really not effective, right? And so one of the underlying assumptions of counter speech and the marketplace of ideas is that there is a counter, right? And if there isn't, you're kind of left without recourse. The other thing I'd say, and I'm curious about this because I know that you have written a little bit about this, is what happens when the counter speech is false, and that falsity just gets echoed and amplified, where we're not really talking about the exchange of ideas, right? It is instead we provide platforms for falsity. That doesn't seem to accomplish the goals, I think, of the First Amendment, which I think, the underlying assumption, true or not, was the marketplace of ideas, and that more is better, and that ultimately we reach truth. I don't know what happens when that fundamental assumption no longer holds true. The other counterpoint to that is one of the things that you didn't really talk about, but which I think is worth exploring, is that censorship cedes power to the authorities. You are putting the people who are in positions of power, you give them the permission and the power to decide what is spoken and what is not spoken. And when you cede that power to, those who are in positions of authority, it's hard to get it back. And you have to trust, you're putting trust in that authority that they will choose wisely, but you've given up your own power. And I think that that's really something to think carefully about when we think about censorship. So those are just my initial preliminary thoughts.
I love that. And I feel that you're in dialogue with yourself. I really love
I am.
And if I may, Dean Scott, I'm not going to be able to answer all of those points in the brief time we have available. I've thought about all of them very much. And I think your last point is the one that ends up being most salient for me. Along with Supreme Court justices, my reason for defending freedom of speech and opposing censorship is not at all because of minimizing or overlooking in any way the enormous harm that speech at least potentially can cause and often does actually cause. And my reason for defending free speech as opposed to censorship is not at all because of a belief that truth and justice are ultimately going to triumph in the marketplace of ideas. That's not what that metaphor suggested when Oliver Wendell Holmes initially created it. Rather, it's that, as he said, truth is more likely to emerge from a contest in the marketplace than by a powerful, hierarchical approach where you have a government official or a campus official, or in these days, a social media tech titan making decisions for the rest of us as to what is true and what is false. So I think
or what can be spoken and what can't be spoken.
Exactly. And what's hateful and what's not hateful. The concept is inherently irreducibly subjective. So we know that Black Lives Matter speech has been attacked as hate speech and even as hate crimes and terroristic speech. The phrase Blue Lives Matter has been denounced as hate speech. The name of the last president of the United States has been attacked as hate speech. The term free speech has been attacked as hate speech. So it's an inherently subjective concept. And once any authority is given the power to enforce that concept, that necessarily means essentially unfettered discretion to enforce it in accordance with that enforcing authority's own values, subjective preferences, or in accordance with powerful voices in the community. And that is why, predictably, censorship is never good for those who lack political power because they are ethnic minorities or because they are political dissidents. And that was exactly the point that was made by Martin Luther King and other leaders of the civil rights movement in this country. Their speech was denounced as hateful and subversive and treasonous and disinformation and every negative term that we now sling against very different kinds of speech. And so we have to ask, it reminds me a little bit of Winston Churchill's famous aphorism about democracy. It's the worst form of government except for all the others that are alternatives, and freedom of speech certainly is extremely dangerous, but I keep coming back to, but I think less dangerous than censorship. And we have to, that's the question we have to answer. I mean, a lot of people start and end this debate by saying, can speech be hurtful and harmful? Yes, it can, but that alone is not enough to justify censorship. And please forgive me for not addressing any more of your points right now, but I give Jayda a chance to weigh in.
Yeah, I can jump in. I just, preparing for this, like some of the thoughts that went through my mind and what this event means and, the book that you wrote, I just, kept going back to my current class that I'm in, Race in the Law, taught by the wonderful Professor Jefferis. We have open discussions about the historical role that race has played in the law. And historically, the Constitution and laws have not favored people of color. For example, the Constitution said, I was property and I was counted as 2/3 of a person, and that separate but equal is okay. And then as a Black person, I'm not a citizen. And then the law started rolling out amendments in order to protect minorities, the 13th Amendment, the 14th Amendment. And then we saw certain case law take the teeth out of that. Mm-hmm. And so traditionally, we've seen America take a step forward in equality and then 2 steps back. Mm-hmm. So I think by not censoring hate speech, are we taking 2 steps back in the fight for equality?
That's a really, really good question. And since you're so learned in this important area of law, let me just throw in some important precepts about First Amendment law, freedom of speech. Freedom of speech is not absolutely protected. I don't know if you've studied that yet, Jayda. I'm sure some people in the audience haven't yet studied it. So let me use this opportunity to just briefly outline that no Supreme Court justice and no civil libertarian or free speech advocate has ever said, whatever you want to say, whenever you want to say it, however you want to say it, it's absolutely protected. No. What we insist upon is that government have a strong burden of proof before it can justify restricting speech. It's the same standard that's used, by the way, under the Equal Protection Clause. Racial classifications are not absolutely unconstitutional. They are presumptively unconstitutional. But if government can satisfy what we lawyers and law students call strict scrutiny and show that the restriction is necessary to promote a countervailing goal of compelling importance. I know the dean has written importantly about this topic. Then the restriction is okay. So if believe me, if I were persuaded that further restrictions on hateful speech beyond those restrictions that are already allowed under the First Amendment, that further restrictions were necessary in order to promote racial justice, I would be all in favor of it. And much more importantly, so would the United States Supreme Court, right? The First Amendment, First Amendment rights, free speech rights are not more valued under the Constitution than equal protection, right? And that's why the fact that there is so much evidence that shows that further restrictions would not, in fact, advance the cause of racial justice, but in fact are likely to do the opposite are very important. You've given me an opportunity to make another point that I really should make, Jayda, which is that hateful speech can be punished in certain circumstances, and never solely because of the mere content or viewpoint of the message. That's not enough to justify censorship because of this principle that the Supreme Court has called the bedrock principle of free speech, viewpoint neutrality. Government may never punish speech solely because of disagreement with its viewpoint. That leads to the dangers that Dean Scott already talked about so eloquently. But if you get beyond the content or the message and you look at the overall context, the facts and circumstances in which the message is uttered, if you can show that in a particular circumstances, that hateful message presents what's usually called an emergency, that it is imminently, directly going to cause certain serious harm, then it can and should be punished. And the Supreme Court has recognized several categories that satisfy the emergency principle. One will sound very familiar. Everybody's been talking about it in the wake of January 6th. Intentional incitement of imminent violence, where the violence is likely to happen imminently. If somebody issues a hateful message and, incites the audience to go out and commit violent actions against the people who are the targets of the hateful message, that's unconstitutionally protected incitement, and it should be punished. Let me give you another example that I think was satisfied by the situation in Charlottesville. Unfortunately, there was a failure of law enforcement to enforce the law there, as a report afterwards thoroughly documented. And that's what is called in law a true threat, where the speaker is targeting a specific individual or a small group of individuals and means to instill a reasonable fear that they are going to be subject to bodily harm. And the speaker doesn't have to intend to carry out the harm, but as long as the speaker intends to create the fear, that's already a harm in and of itself, right? Because you're then going to be chilled in exercising your right to counter demonstrate and to counter speak. So yes, I think the judge was right in saying that the city council could not withdraw the permit for the white supremacist demonstrators just because of their horribly odious messages, which make my skin crawl as I think about it. But when they went beyond that and started marching en masse to physically confront the counter demonstrators in a menacing way, brandishing lighted tiki torches and firearms, that to me was a punishable true threat and should have been punished. So I guess what I'm saying is I don't think that we need to go beyond the capabilities that already exist. But I'd love to hear if you would suggest another type of speech that's now hateful speech that's now protected, where you think it would advance racial justice for us to loosen up the standards. I'm all ears.
Maybe I'll give Jayda a moment to think about that and not put her on the spot. But I wanted to bring up another. I certainly don't have the answer, but I did want to bring up another thread that I think is interwoven throughout these conversations, and it picks up on Jayda's point and also on Dean Scott's remarks about power. It's a little bit of a different conceptualization of power in the relationship of speech, though, and of course, during this week, there's been a lot of debate in the media about the role of the ACLU and the ACLU's view of free speech and whether there's a culture crisis happening in the ACLU because of this perceived tension between robust free speech and the advancement of human rights and racial justice and gender equality. And this idea was definitely present when I was at the ACLU, and I think I'm certain that it's still there, but this notion that not all speech is uttered from the same place or from a place of equality. Speech is often linked inextricably to power, and that power comes from the speaker's platform, right? So it could be the power of the federal government or the office of the White House, the power that comes from a massive social media following, the power of an organization with the resources like the ACLU, even the power of a professor in a law school classroom who chooses the cases that she assigns and the material that she covers. And then of course, the power and privilege that comes with being a member of a majority group, whether that stems from one's whiteness, one's gender, one's wealth, etc. So if we're adhering to these robust free speech principles, but also trying to be mindful and intentional about fostering equity, how do we reckon with this idea that speakers and the choices that they make about speech are wrapped up in the inequitable allocation of power and privilege?
It's a tragic fact that not only free speech, but every right is more greatly enjoyed by those who have access to power. I mean, think of in the most dramatic example within the criminal so-called justice system, the criminal legal system, in terms of who gets prosecuted, who gets convicted, who gets acquitted, and that's most dramatically disparate when it comes to the death penalty. I remember many, many years ago, a prison warden who had become sickened at the unjust administration of the death penalty said, why do we call it capital punishment when the only people who get it are the people without capital? I mean, yes, it's horrific that some people have, as a practical matter, fewer free speech opportunities. They have a theoretical right, but they can't practically realize it. Yeah, you have a right to a fair trial and due process, but if you don't have the money, I'm sure, great public defenders like, as Jayda might become, or just don't have as many resources as lawyers in the private sector. So this is a general problem that affects our, everything about our society, including legal rights. And that's why I am so fiercely proud of the ACLU's role in not selectively defending only free speech as some kind of abstract, absolute principle, but rather defending it in a much broader context of human rights, where we are aspiring to help our country, continue in this process that Jayda so eloquently described of, we had at the very beginning, we said that all men, meaning all human beings, are created equal. We were so dramatically far away from it then, but we've been making progress. Sometimes it's one step forward and two steps back, as Jayda said. Sometimes it's two steps forward and one step back. But the goal is equal, meaningful rights for everybody. And in the meantime, that means doing everything we can to empower people without resources to get access to the resources that will give them communication skills, communications technology. To me, it was a major reason why the ACLU was in the forefront of defending freedom of speech for the internet. And I will forever be so proud that the Supreme Court's first case about the First Amendment in cyberspace is called Reno, as in Janet Reno, Bill Clinton's Attorney General, against ACLU, because we recognized that the internet would at least potentially empower everybody to communicate with everybody else. And we see there's been a great move toward equalization, Danielle, that many professors don't feel that the power lies with them. They feel that the power lies with students who can make complaints and, drum up a social media campaign against the choices that the professor has made. That it doesn't lie with a CEO, but with employees who are protesting some of the CEO's policies. We've seen many dramatic examples of this every week, where groups that used to be less powerful because of organizational hierarchies or educational differences or money differences, thanks to the power of social media, are able to raise their voices in very unprecedentedly effective ways.
I'd also say that censorship doesn't create any more power, right? So the censorship doesn't empower me. The censorship empowers whoever is in the position of authority. So Danielle, to your point, if it is the authority that comes in and says you may not speak, that doesn't empower me, right? It may end up stopping the person who is engaging in the speech, but they're not stopping it because of my exercise of power. So it doesn't create agency for me, right? So this is the challenge. I mean, it's no small thing, right, to think about the power of the state. And as you are teaching, and as I have taught, when I have taught the class that you are teaching, the power of the state is what has marginalized and minoritized us. So I'm not sure that I feel comfortable turning to the state as my savior and giving back that kind of power. I don't feel as though my agency is increased at all.
It made that very, very helpful points. And I'd like to go back to Jayda. I don't mean to put you on the spot, but if you feel like answering this, I'd love to hear if ideas that you have specifically in law school, of what could professors and the dean and others do to give students more of a sense of power and more actual power? Do you think I mean, for example, Danielle talked about the professors set the curriculum and the syllabus. Do you think that students should be involved in that in some way?
I am a big advocate for students having a seat at the table. It's something that I definitely want to, take on as boss of president. But I think, that's a start, having student voices heard at a higher level. I know we can't be heard at all levels of the law school. That's, just maybe not practical. But the more student voices are heard, I think, it creates a safer environment for students. As far as I think it's a balance in a law school, because you can say, let's censor hate speech, it shouldn't be said. And then, we practice law. We are trained to counter speech. We're trained to do that. We are trained to have an argument ready to go. And that's what we do. So I could see the benefits in having the opportunity to counter someone who says hateful speech to me. But at the same time, I could be deeply hurt and affected by what is said and, not want to speak. I could be deeply afraid of this person now because they've said something very hateful to me, therefore taking away my opportunity to address them with any counter speech. So I think it's a hard balance. It's a hard,
We always use
all the way over.
in law, we constantly use the phrase a delicate balance, and that's exactly what this is.
I would say, Jayda, I think you made a really good point, which is, for me, when I think about my role as dean, I want you to be empowered. I want you to be an advocate for yourself and for the people who in a very short time are going to be relying on you to be their advocates. And that's you have to be, people come to you in crisis. And because nobody just kind of wants to have a friendly chat with their lawyer. So they come in crisis. And so there's a real big part of me that feels that I've got to send you out of the door prepared to take on the fights that you will encounter, both in terms of your professional life and honestly, in terms of your personal life. Because the hate that is waiting for you, the higher the stakes are, the higher you go up on the professional ladder, the resentment and the envy and the fear kind of multiply. They don't go away. I've had some very interesting conversations with alums as, kind of meet the new dean. And it has struck me a couple of times when people have said, I was not prepared when I went to Arizona and was the only Asian American in the court, and somebody did this to me. Mm-hmm. Cal Western didn't prepare me for that. And so the emphasis on not just cultural competency, but, to call it what it is, the hate that we will encounter. I don't want to send you out unprepared for that. And I'm not sure that I know how best to arm you. I struggle with that, right? I struggle with that as a dean. I struggle with that as a professor. Honestly, I struggle with that as a mom, right? Of two young women brown women, that I send out into the world. I don't have the answer, but it is something like you just identified. There's a balance that I try to strike, and it's tough. I don't, not always going to get it right.
I could not agree with you more, Dean Scott, and sorry to keep asking you questions, Jayda, but as our only student representative on the panel, does it help if we go through the explanation that Dean Scott went through, that the reason that, and by the way, this is, I guess, a question for both you and Danielle in your racial justice course. Some professors now are debating not teaching their students the Dred Scott case, or not just debating, they've decided that they're not going to teach Dred Scott, or they're going to teach a very expurgated version of it, or Plessy versus Ferguson, because they don't want to subject their students to the racist language and the white supremacist holding. So, one question is, how is that being handled in your course? The other question is, if it is included, but with an explanation that, we are aware of how terribly traumatic it is to read this. As a white person who's deeply committed to human rights, it's traumatic to read it. Even more so, I assume, for an African-American person. But look, the reason that we're doing it is, the reason that we want you to encounter this is so that you can be better equipped to stand up for your rights and to advance the rights of your clients and of your community. Does that help when that kind of context and professional purpose is spelled out? The reason I ask is because some people are saying, we don't care what the intent is. We just don't want to hear that language at all.
I think, as a student and as a person of color, it is very important to read these type of cases. It's part of our history, and to not teach it is kind of, I think, of trying to, whitewash our history. It's here, it happened, and there's no getting around that. And by not teaching it, I think that's, for lack of a better words, it's a cop-out. Because you have to, and especially at the law school, right? That's part of preparing us for the hard world. And if I know that in the law, this is how I would, in the past is how I was treated, and this is what they said, well, okay, we've made a lot of changes, but, prepare me for that going out, that's happened. So something similar, hopefully not anything similar, but something, along those same lines could happen. And I need to be prepared for that, because the Supreme Court has said it before, more progressive minds, hopefully they won't say it again, or, anything like that. But I do think it's important to address the language, to say this case was written so long ago, this was the language they used, but definitely not to say the language. I think in the class, that doesn't need to be said. I can read, and I read the words in the case, and, people of color, that's it, a Black person, that's what we need to say, instead of some of these terms that were written in the case books. And part of that, maybe we should be updating our case books. And, that was the way it was written, but I know there's, I think Professor Jefferis, or you talked about a group that is like trying to rewrite case law in a women's perspective. Was that you?
Vice Dean Brenner Johnson did, from the critical feminist perspective. Yeah.
And I think something like that is just, take that language out, or, just something like that. There's certain reasons we read a case, and it's not for the words in the case. It's to get the holding, to get, the rule. And that's why we read it as lawyers. So I think something like that could be helpful, but not teaching it, I don't think that's the best way. So not complete censorship of the case, but, there's ways to not address that type of language, because I think it adds no value to the conversation other than to hurt people.
May I say something? So I'm going to respectfully dissent just from my own perspective. And these are very personal reactions that we have to everything we read, right? But you said, Jayda, that African Americans were treated as property, and that certainly was the legal status. But it never really hit home to me until the first time I read the Dred Scott case. And please forgive me, I'm gonna quote something. It's a pronoun. I'm sorry, I'm bad at grammar. It's an article of speech. When Dred Scott was referred to not as he, but as it. I'm still getting chills when I think of that. That two-letter word. To me, that brought the power, what it meant. in a way that just, saying that he was treated as property never did. So I'm glad that I read that unexpurgated passage. It really underscored in the most profound way the shocking nature of the dehumanization of African Americans.
I really don't want to divert us from this particular subtopic, but there have been a few questions. Nadine, if I could pull in some of the audience questions. There's several questions on the role of hate speech with respect to hate crimes, which you touched on, and particularly one attendee asked, do you think protecting hate speech has an impact on hate crimes, and if so, what is it? And then at what point do laws criminalizing hate speech, or excuse me, hate crimes become tone policing, or go too far into the speech realm?
Those are two very different, excellent questions. The first one, I have found very, very little social science evidence one way or the other. Can you show a causal impact between the existence of hateful rhetoric in society and the commission of hateful crimes or discrimination? This is part of the difficulty of studying what I think in communications theory is called media effects. It's extremely difficult to tease out what the connection is between any kind of rhetoric and any kind of action once you get beyond the really tight and direct causal connection that the Supreme Court has demanded in, for example, concepts such as intentional incitement to imminent violence and true threats. Because to all of us are, of course, affected by everything we hear, see, or read. But there's an infinite amount of that, and there are infinite other factors that will affect how we process what we hear. So take Charlottesville, for example. I assume that some people who heard those marchers watched them saying, you will not replace us, Jews will not replace us. I assume there were some people who were motivated by that speech to, hate racial minorities and Jews even more and to plot to do something about us. But I also know that there was this overwhelming upsurge that I described earlier of people who were so revolted by that they were galvanized into counteraction and to redouble their efforts to fight white supremacy. So it's a very complicated interaction between hateful speech and hateful actions. The second part of the question was exactly what the ACLU debated until we were, we had a very close vote on whether we would even support the concept of hate crimes or bias crimes, because the argument against it is that, well, it's a thought crime. If you get a 5-year sentence for committing an assault, but, a 10-year sentence if it's an assault against somebody that you discriminate against, isn't that extra 5 years punishing the thought? And isn't that inconsistent with freedom of speech and freedom of thought? It's a plausible argument. I sided with the other argument, which is why I think conceptually it makes more sense to think of it as a bias crime, a discriminatory crime. In our society, we have employment at will, for better or worse, I think, but basically means that an employer has a right to refuse to hire you or to fire you for any reason at all, except if it's a discriminatory reason on the basis of race, gender, national origin, and so forth. So it seems to me that a fortiori, as we lawyers say, or even more strongly, if we take something that's completely illegal and we can make it completely legal, namely, discrimination in employment, but make it illegal when it's discrimination on certain grounds, then even more strongly, we can take something that's already illegal, a crime, assault, vandalism, and say it's a more serious crime when it's committed for a discriminatory reason. However, that said, we recognize the great danger that this would become an area that was open to discretion, where the police could and the prosecutors could say, well, somebody said something discriminatory and use that to ratchet up the charges. And we were especially afraid, and we've seen this happen, that as with so many criminal laws that give discretion, they would be disproportionately enforced against young Black men, right? And that unfortunately is what we have seen, that many so-called hate crimes prosecutions are brought against men for Black, brown men for resisting arrest. And then they're charged with hate crimes against police officers. So we have to be very careful that the law is written in a very narrow way and enforced in a non-discriminatory way.
That is great. Thank you. We only have a few minutes left, so I want to make sure that Dean Scott or Jayda don't have any thing additional to add, but we do have a couple of questions that would be a really nice wrap up on an optimistic note for us. So I will read one. Dean Scott, the last comment that you made really spoke to me. Our faculty and student leaders have this duty to equip all students on campus for this profession. The topic of hate speech and counter speech almost calls the question on whether a class should be offered and dedicated solely on educating law students on how to combat this, not only to prepare for us personally or for a courtroom, but especially when we confront future clients who may partake in that conduct. Mm-hmm. And then the question is relatedly, how can I use my role as a law student to empower the community now?
I think that that's a fabulous idea. I think, and so I'm grateful for the student who raised it. I think sometimes the hurt when it comes is just so paralyzing. And you feel so unprepared, and you think for the moment, could that person just really have said what they just said to me? And the answer is yes. So I think it's a fabulous idea to bring together, to bring together not a class, not only where we share those personal experiences, but where we really equip people to have a sense of their agency and their own power, and figuring out how do we manage. So I think that is a fabulous idea.
I couldn't agree more. That's fantastic. Social psychologists have said that in addition to the strategy that you mentioned, Dean Scott, that basically cognitive behavior therapy ways of thinking can be instilled, and all of us can be trained in it. So we learn to be resilient and to not empower somebody to be able to damage our own self-confidence, that it makes us look down on them rather than vice versa. I think if that kind of course were developed, it would be just phenomenal for other law schools and undergraduates, high schools, middle schools.
I agree completely. And I will put her on blast because that was a great friend of mine who asked the question. Great job. And I do think something like that at California Western would be really great. And on that note, just education is one of the key, solutions here, and not just that such, a high level of, we're law school. This might be the end, the end of education for us, but at such a lower level before these ideas of hate are even seated in young minds, that, we need to educate them on why that is wrong. Before it kind of enters the world is something I think that could be effective towards hate speech. I'm still teetering with the idea of censorship and not censoring it, but this talk has definitely helped some of those
Even if in the most repressive form of censorship, though, Jayda, it's not going to eliminate 100%. It's going to be impossible. So you're going to encounter it even in a censorial regime. So better be prepared.
All right, well, that is a perfect ending at the exact moment that we said we would end. So being respectful of everyone's time. I don't know if anyone has any last parting comments that they want to add. I will just re-emphasize the last question was, how can I use my role as a law student to empower the community? So part of that I hear is education, but I don't know if anyone else has any thoughts. Speech.
I look forward to seeing the course that is designed as a result of Jayda's friend's fantastic suggestion and the dean's positive response to it. I think you could, continue to put you on the map as I saw that you're one of the top law schools in the country in terms of ethnic diversity. So how appropriate to have this kind of empowering element of the curriculum come from your school.
The best thing you can do as a law student, and is to get your degree, figure out always, no matter how you go forward, that there is you have to commit to living a life of purpose. And that purpose is going to be different for each of us. But take advantage of every opportunity that comes your way to hone your skills, to hone your craft, to connect with the things that matter to you. To me, the best thing that you can do as a law student is to take this education and let it enhance the opportunities for you and the community and issues about which you care deeply. That's the best thing that you can do. And the best thing that I can do is try to empower you to do that. But then when I present you with the opportunities, take them, right? Take them seriously, then take them to heart. That's what I want you as my law students to do.
Amen. Amen.
All right, on that note, thank you so much. Thank you, Dean Scott. Thank you, Nadine, Jayda, so much for your thoughts and participation and time tonight. Thank you everyone who attended and who submitted thoughtful questions. I'm sorry that we could not get to all of them, but we could speak for hours on this topic, years, as Nadine knows. So thank you so much, everyone, and have a great rest of your night.
Thank you, Professor Jefferis.